All rise. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, the United States Constitution is on the board.
Good morning. Please be seated. Okay. The case before us is USPLS and versus Patrick Gass. Is that pronounced correctly?
Goss.
And Daniel Shank. How are we going to call USPLS? I'm not doing that for 15 minutes.
You could call them PLS.
PLS, okay, I can do that.
Plaintiff or appellant.
Okay. So I understand you want 8 and 7 minutes, so that's fine. Let's begin. Please come forward. So I'm going to start off with a question. I know you have a bunch of, and I will take my question. You can answer it or do your PowerPoint.
Yes, sir.
My question is, let's just assume for a moment that there is a contract, which I'm not sure there is, but Goss is saying that you didn't perform, and I'd like you to really discuss that. How can we say that you performed the contract? And then secondly, how can you say you have damages when the contract would have been with a third party?
Okay.
Are you able to hear me?
I am,
Okay.
yes.
Okay.
With respect to performance, I believe our slides are...
By the way, we'll stop for just a second. You're Mr. Spence, right?
Yes, I am. Ross Spence for PLS. Justin Safety is with me. Jim Wilson's the principal of PLS.
Okay. I'm sorry I've lost my formalities. It's been 2 years.
Yes.
Okay, and then would you like to make your announcement?
Josh Smith for Applebee's, Your Honor.
Okay.
I'm here with my colleague, Jacob Thomas.
Okay, thank you very much. All right, let us begin.
All right, Your Honor. The court has asked, may it please the court, Your Honor, the court has asked about performance by the plaintiff PLS. PLS, upon the acceptance of their terms, basically immediately began meeting and communicating regularly with the lawyers who wanted to find new employment, discussing which firms to contact first and which to contact second in the order, and then contacted all of the priority firms and 2 of the non-priority firms. They got that far before the appellees decided they would just go off on their own. In a lot of cases that we've cited, that kind of a part performance renders the contract absolute. It becomes, even if it were not a valid contract, that performance made the contract binding, even if it's part performance.
Okay, what about damages?
Okay, and on damages, I think what the defendants say is, well, but we will never know what your fee agreement would have been with Kilpatrick, this firm that they landed at. And our point is, and all the cases say, that if they breach, then that's considered that future condition and that contingency that could have happened but never did is considered fulfilled. This court has said that in Dorset v. Cross.
Well, wouldn't it, I guess, make more sense if you've got a contract like that to put on the lawyers an obligation wherever they're ultimately hired to have their firm pay you 15% or to pay you 15% or whatever X amount of money would be. But here it's just left open, where it seems like the onus is on USP to ultimately enter into a contract with somebody else. And here you're seeking damages, not from KTS, but you're here seeking damages from somebody who doesn't, there's nothing in the email exchange that says they're to pay you X amount. So is there a case that's on point that?
I think there is, Your Honor.
Okay.
There's a long line of cases that Park versus Schwartz is one of, a Texas Supreme Court case. They cite to Eberts. Eberts was cited by this Clear Lake City versus Friendswood case and the Erdman case, all of which we cited. And then we admittedly cited to a line of Florida and Illinois cases, but that's because they cited to Eberts and then ran with it. There's a whole line of jurisprudence about if Defendants Act made it impossible for the plaintiffs to prove just what damages they had suffered, the plaintiff was entitled to recover the maximum amount of damages. And in that case, they said the maximum amount of commission which he could have earned. So that the fact finder has to presume that he would have, if the introduction had been made, which this contract does require. It doesn't require them to get a stipulation in their landing firm's contract to pay a certain percent, but it does say they have to introduce and acknowledge and confirm the agency of PLS. And by that means that PLS is their agent, their exclusive agent, and that firm will now have to negotiate a fee with PLS.
The Goss was never going to pay any money. They never agreed to pay you money.
That's right.
That's what I don't understand. It sounds like kind of a quantum merit, sort of, but firstly, you didn't plead that. But secondly, I'm not sure you'd be entitled to it. That's why I'm kind of befuddled about how you could come up with your damage model.
Okay, that's what this line of cases says. It's not a quantum merit situation. They actually address that. And they say what it is the acts of these parties prevented the occurrence of a condition with a third party, a buyer, let's call it. And they cite a bunch of broker cases. He's not a broker, but even if he was, the cases say that it's presumed he would have engaged and gotten an agreement with that buyer and gotten paid a normal, ordinary commission. In fact, what they say is the maximum commission that he could have earned.
What would happen if, say, they had landed at a firm that has policy that says we don't pay headhunters, period, never?
He would have been negotiating with that firm, and no one knows what would have happened, I guess. But I think what you're talking about is, do they have a right to self-deal? In other words, do they have a right, even though they entered into agreements with PLS to be their exclusive agent with all firms, can they still just negotiate on their own with any firm?
So does that mean they're restricted to working only with firms that PLS can get an agreement with?
It might. Not sure. We don't have that fact in this case. In fact, in this case, Kilpatrick admits that it does pay fees to these kind of placement professionals. And so Eberts is a case where the other party prevented the occurrence of the condition of Eberts getting paid his oil proceeds by destroying the wells. And they had a reason to destroy the wells, but that it says Eberts was entitled to recover the full value of their promises, and that is the maximum amount of the oil payment if the destruction of the wells had not occurred. And the Clear Lake City versus Friendswood case is not the same facts, but it's factually on point. The third,
Which case is it?
it's called Clear Lake City versus Friendswood, and it is 344 Southwest 3rd.
It's from the 14th court, right?
Yes, it's a 14th court of appeals. And it actually went to the Supreme Court twice. And then this one is petition denied. In that case, the contingency was actually a bond offer or a bond vote. So no one knew if the county would approve, the voters would approve a bond that would then pay Friendswood. And in that case, they said because the city breached, it prevented even the vote from happening. It's presumed that the vote would have passed, and that they then would have been entitled to be paid.
Why wouldn't it, I guess, why isn't the obligation on the, I guess, your client here to include something like in the contract that obligates the attorneys to pay if they, go outside the agency relationship?
I mean, I don't know of a provision in law that requires a specification of damages. You don't have to spell out your damages. And so, in most contracts you don't actually, but when they breach, it's just understood. If you breach a contract, you can be liable in damages.
Okay, let's hear from the other side. Your time's up. Mr. Smith.
May it please the court, I'd like to address 3 points. First, I'd like to address the issue of performance. Then I'd like to turn to the issue of damages. And finally, I'd like to turn to the issue that the headhunter touched on but didn't really grapple with, and that's what is even the meaning of the terms of this purported agreement. So first, the question of performance. It's undisputed on this record that the headhunter never even intended to contact the Kilpatrick firm that the plaintiffs, or that the attorneys ended up at.
That is not all of the performance that was expected. You were asking them to look at it, I don't know how many firms it was, so I'm not sure I like that argument.
Your Honor, this court's precedent and the settled law in Texas is that when you have a claim based on partial performance, which the headhunter has not even alleged here as far as the type of damages that you'd be entitled to, you are only entitled to reliance damages for a claim for partial performance. This court held that in Sewing versus Bowman, 371 Southwest 3rd, 321 at page 347. They have not alleged, they have not attempted to recover. Their theory of damages is not based on reliance, it's based on this outlandish $1.2 million that they say some other firm, not Kilpatrick, would have paid. And I'd like to turn to that point.
Actually, I hate to take you off your train of thought, but I need to ask this question before you move on.
Yes, Your Honor.
What, just in a bigger picture sense, what is your argument as to what was the exclusivity in this agreement or in this arrangement?
I think that the arrangement that the plaintiff has sued on, the purported contract, it requires exclusivity only as to there won't be any headhunters. We promised that there will not be any headhunters, any other agents that we employ in the course of seeking employment. It was not a promise not to conduct the search ourselves. And that flows directly from the text of the compensation provision that was pointed out in the plaintiff's presentation. It states, and I quote, that the, quote, sole compensation is the contingency fee paid by its law firm client in the event it acquires it. The promise was that's the sole source of compensation. And I think it's useful to take a step backwards when it comes to what's the nature of this exclusivity, the alleged exclusivity provision, and go in 3 steps. The first step, and it's something that the headhunter thus far has not grappled with, is what is the meaning of the term agent, of agency, as used in the purported agreement? Second, what does the case law say the meaning of an exclusive agency relationship is? And third, what do the terms of this document that they've sued on mean? Now, the plain and ordinary meaning of agent, as this court held in the Tran v. Kong Development Corps decision, 2014 Westlaw 4219470, the plain and ordinary meaning of that is a person or business authorized to act on another's behalf. Now, that case was citing a Supreme Court decision which was citing Webster's. Black's Law Dictionary contains a similar definition. And the reason that's important is because the essence of agency is not a promise to provide opportunities or boundless opportunities to act on the principal's behalf. The essence of agency is provision of authority. So when we see the word agency or agent in this alleged contract, the meaning is there's authority given. It's not a promise to provide opportunity. Now, when we turn to what does it mean to be an exclusive agent, we spelled out the line of authorities in our brief. I'd point the court to the Alba Tool decision, the Supreme Court decision, the Baker v. Skipworth decision. The meaning of an exclusive agency is simply a promise that we won't have any other agents. We won't give our authority to any other parties. It's not a promise not to compete with the agent, the principal, but it's well settled that a principal is entitled to perform their own negotiations on their own behalf when there's an exclusive agency.
Well, how does
As-
this work with like realtor contracts, for example? Like if you go into a contract to work with a particular realtor, usually the standard form, even though the realtor is acting as your agent, if you go find another house in the same area, you're going to owe the realtor that you signed with the realtor's fee at the end of the day if you go off by yourself and enter into a housing contract. So is that somehow different than what's going on here? Or?
Your Honor, to the extent that that's the case, that's because a lot of real estate contract or listing agreements these days have not only an exclusive listing clause, but also an exclusive right to sell clause. And so that's exactly what the Supreme Court has gotten at in this line of cases, is that there's a difference between granting someone an exclusive agency, granting them an exclusive right to sell. Otherwise, you turn the agency relationship on its head by requiring the principal to bring business opportunities to the agent, to bring the principal's own skill, the principal's own connections, the principal's own opportunities to the agent. And unless that's been specifically bargained for, there's no reason to turn the principal into working for the agent as opposed to the other way around.
Do you agree that if your client had connected a PLS with KTS and brought them in, and then for some reason unbeknownst to us, the PLS was unable to come to some sort of a fee agreement with the firm, does that mean that those lawyers were never allowed then to accept employment with that firm?
I don't think that's what this contract says at all, Your Honor. It says that in the event that there is, that they are placed by one of PLS's law firm clients, then the headhunter will be entitled to compensation. But that, in your hypothetical, that simply didn't happen. And neither did it happen in the real world. And I think that takes us to the text of the purported agreement. Again, the essence of a promise of agency is simply a promise to give authority, not a promise to use them in that opportunity. Otherwise, again, you'd have the principals working on behalf of the agent, which is simply not the way it works.
Well, if we do see this as a contract for an opportunity, is there still an argument that they're not entitled to damages, even if that theory is correct?
That's exactly right, Your Honor. First, and I think the most important point about damages is something that the headhunter hasn't really grappled with on appeal, and I point the court to tab 2 of our bench exhibits. That is page number 1 and page number 2 of the headhunter's summary judgment response, where the headhunter affirmatively disclaims any intent to try to recover the fee that Kilpatrick might have paid if the headhunter had been looped into those negotiations. Your Honor, the headhunter's theory of the case is that we breached by not looping the headhunter into those negotiations. Therefore, the only damages that he might have a right to expect would be the fee that Kilpatrick might have paid. But he told the trial court in no uncertain terms, that's not what I'm seeking. He has disclaimed, waived, abandoned several times over the only theory of expectancy damages that the law might entitle him to. And so I think the point is, how can he recover a theory of damages that he told the trial judge he was not seeking? What he said he was seeking was some theory of damages based on agreements that he had reached with other law firms that he had no right to expect the attorneys to go to. That's not expectancy damages. That's a windfall. The law does not countenance that theory of damages, and without a viable theory of damages, there's no point in a remand. So I think the answer to your question is precisely, first, the fact that they've waived it, and second, if the court turns later on to, in tab 2 of our bench exhibit, the court will see the testimony of the headhunter, where he said that he would not be able to predict the fee that Kilpatrick might have paid. He said, it is speculative. That's why I'm not seeking it. Well, the standard for recovery of damages, it cannot be speculative. He's disproven his own theory of the case. Even if he were seeking that measure of damages, he said he can't prove it. Again, he has nothing to recover here. So on the text of the purported agreement, there was a promise at most that he would have exclusive authority that he would be the exclusive person that we granted authority to negotiate on our behalf. That's very different from an arrangement where you say that we will not negotiate on our own behalf at all. That defies the Supreme Court's teachings. It defies the text of this purported agreement. Nor did the headhunter perform, nor does he have any viable measure of damages. We've laid out additional paths to affirmance in our briefing. I'd be glad to answer any questions about those. There's 5 separate paths to affirmance, but unless the court has any further questions, I'm happy to cede my time.
Thank you very much. Thank you. Mr. Spence, we haven't even talked about whether or not we have a contract here, what the elements are, what matter might not be missing from the contract. Maybe you should spend some time on that. And that's putting aside the fact that you have an agreed judgment. So you gotta figure out what you're gonna do with your 7 minutes.
Okay. Well, first, on those couple of points that were just made, he said that he can't prove it, what Kilpatrick would have paid. Well, it doesn't, the plaintiff himself doesn't have to prove it, just you have to prove damages in the trial. Damages are presumed in all of the cases that we've cited. They say the party in breach cannot benefit and prosper from their breach. They don't get to say, you can't prove your damages because we prevented you from
What
proving your
about his
damages.
argument that you only are entitled to reliance damages?
That's wrong. These cases say you're entitled to the benefit of your bargain. And then secondly, the promise of agency, they said, is to provide authority. That's a certain kind of agent where you appoint someone agent to negotiate contracts for you. This is not that kind of agency at all. There are all many kinds of agency. This is not an agency where the lawyers just ceded to PLS the right to negotiate their salaries and where they're going to work. That's not at all the type of agency we have here. They gave him authority, and the agency specifically says to participate in all of their employment negotiations with all firms. They don't get to go off with some other firm because they said all firms. And the cases actually say that. We cited both agent and broker are both defined in Robles v. Consolidated Graphics. The all means all was stated in Popplewell and Rogier that we cited, and in French v. Love, the parties they talk about this line of cases, Popplewell, Johnson, and Moran, and they say that if they didn't expressly reserve a right to self-deal, they breached the contract because the exclusive agency, where it's for a period of time, which this was, it's for a whole year, all firms, you can't just go off on your own. That's what all those cases say, and if you do, then you now become liable for the damages that the third party would.
I think you're turning it into a right to sell. Your argument, it was a right to sell, but it really wasn't a right to sell, was it? Because there was nothing in the contract that said that, if it was a contract.
That's actually their argument. I'm just responding.
Well, I'm asking you to respond.
Yeah, if they involved our client in all firm discussions, he would have negotiated a fee. He's never not.
What happened to KTS? Why didn't you apply to talk to them?
Because they were on the secondary list and were never asked. He can't just go talk to a firm and say, I've got these 2 lawyers, they need this much money. He doesn't have that right. They have to direct their agent. A principal has control over the agent. That's what all the cases say.
So on the element of contract formation here, I mean, it at least looks like from the record that the parties are behaving as though there's some type of an agreement in place. Does that matter under Texas law?
Yeah, absolutely. No case they cited is even remotely like this case, where they accepted not only once but twice. They said, I spoke with Pat Goss and Dan Shank. We have agreed to engage you. And the answer is good. Let's get the show on the road. And they say, what else do we need to do? Well, just give me the excluded firm that you didn't tell me who you're trying to exclude. What firms do you want to exclude from the list? Otherwise, it's all firms.
Well, was it, I mean, you had from January to September, so you just didn't have enough time to get a hold of KTS?
No, I think that the answer.
It definitely was a definite ad.
They were an add to the list, but they were not on the priority part of the list.
Okay, so you just didn't have time to get to the.
I don't think it's that it was lack of time. Certainly, we could have contacted them in 1 day's notice, but they never asked us to. They never mentioned that firm again, from then through the breach. And then on acceptance, so anyway, they accepted that on the 23rd, and then on the 27th, we accept and agree to work with PLS exclusively in the terms set forth below. Excluded firms are K&L Gates. And then they repeated our terms. So those are the terms of the agreement. You have a clear indication that both parties thought they had an agreement, and then from then on they acted as if they did. In fact, they included PLS in firms where they actually knew people and made the first introduction. They said, oh, but that's our agent. You're included in this deal. So they acknowledged it until they decided not to. That's really what happened. And then on damages, you're entitled to the presumption that all the conditions would have been fulfilled. A jury will have to find out, maybe a jury finds 0. I don't think they will, but it's possible. But every time that he approached a firm and they did have an interest in this group, he did get a fee agreement. And the fee agreements range from $1 million on up. So a jury can look at that evidence, and then can look at their argument that Kilpatrick wouldn't have paid you, no matter what, they wouldn't have paid you a nickel. I don't think that's the standard, but we have proof that Kilpatrick pays other professional placement agencies all the time. So I think a jury will decide the amount, but the fact of damages, which is all you need to defeat a summary judgment, has been proved. And then he was asked about the agreed judgment. All the cases they cite to are distinguishable in that the judgment itself recites that there's an agreement of the parties, or they announce in open court, we have an agreement, or this is our Rule 11, we're settling the case. That becomes a consent judgment. When you don't do that, it's not, even if you say agreed. If you say agreed in your judgment.
Okay, but every trial lawyer in this room knows that if you are agreeing to a judgment, then you better agree to it, or you have to, put approved as to form. How many times have you, in your any motion or order that ends up being put in place, you agree to it, or you agree to it only in form?
That's better practice. I will grant you that. And,
okay.
And in this case, it says it is appealable, and the motion that asks for the entry of this agreed order says it's being agreed so that it can be appealed.
All right, what's your case on that?
And Daniels versus Indemnity, 2013 to Westlaw 3770955. I think they cited that. And they cited Declaris Associates v. McCoy, 331 Southwest 3rd 556. Both were agreed judgments. And yet they said, no, but that doesn't mean you've lost the right to appeal. It's clear that a summary judgment was granted against you, or a trial was against you, and you wanted to appeal.
But the documents you talked about earlier that show that the whole reason that you guys came up with an agreed judgment was to facilitate appeal, are those actually in the record? Weren't those just part of a reply brief?
You're right. Two documents. We didn't know they were making this argument until then. In other words, we file a motion where we both agree that the purpose is to make it final so we can appeal. And then they didn't even ask for that agreed judgment to be put in this record until like 9 months later. And at that point,
well, it was part of the trial court record. I mean, the agreed judgment
was in the trial court.
right?
Yeah,
so
but
it's
both
part
parties
of the
supplemented the record, did everything.
Yeah.
But they supplemented with that piece after we filed our brief. That's why it was in the reply. But the motion itself is in the appellate record, and it says that the reason that they filed, paragraph 6 of that motion says, we file this so that we can appeal, both parties. And it's an agreed joint motion. Any further questions?
Anything? No. Okay, thank you very much for your arguments.
All rise.
It is nice to be back in person too.
very.
Yes, it is.